I want to now turn it over back to my previously introduced Alan Schwartzseid from our Orlando location. Alan, good morning. How are you today?
Doing all right. Thank you, Jeff.
Sweet. The floor is yours.
All
Screen
right.
share
Thank you, sir.
enabled, and we are ready to get going after you get it up there.
All right. I'm going to actually ask you to run the slides until I turn my monitor back sideways because I have it vertically, and we had a problem with that during the last webinar.
Oh, you got it.
While you get set up, and I'll appreciate your help with that. Fortunately, we only have 10 substantive slides today, so it's not the end of the world that it's going to take us a minute. But I will explain who I am, what we do, and just appreciation for you all being here. So I'm going to start by clarifying a point that Jeff made, that if you don't have an attorney, we would be happy to hear from you. I'm going to add that even if you do have an attorney, we'd be happy to. A lot of times, because we don't have any kind of monthly minimums or annual fees to generally work with our firm, it's not an upfront retainer cost. There are a lot of firms, or a lot of associations that we work with that kind of use me or our firm as secondary counsel, or use us as primary, but have another attorney that they like to work with for certain purposes. So just leaving that out there, so to speak. So welcome to our governing documents webinar. I do think that a lot of the material that we present is not actually what the class is labeled as, and that's thanks to the state to a large extent. And so I've actually added, not to the slides, but just to my little notes here, some materials that are frankly a lot more relevant, in my opinion, to the subject matter of why updating the governing documents is important than what's actually in our slides here. So as Jeff mentioned, I am the managing partner of our KBR Orlando office. We've got 4 offices, one here, one in Tampa, one in Palm Beach Gardens, and one in Pompano Beach, which is our main office. This is literally all we do. Representing community associations has been our primary or sole business since the 1990s. And so if you've got questions regarding community association law, we are the right people to reach out to. I like to be a resource to everyone in Florida, frankly, so that I deal with less people screwing it up and I have to fix it. I'd much rather not get paid to give you a 30-second answer than you have to pay me thousands of dollars to fix your mistake. So my email is on this first slide. You are welcome to email me anytime with questions. We generally don't represent individuals. It's almost exclusively the associations themselves, but that is the business we're in. We've got 8 attorneys who are board certified in this area of law, which is representing community associations. Another who does construction law, so that's not the topic today, but if you have construction defect issues or any other building or construction issues in your community, there's really nothing that we need to farm out to somebody else. So we are very specific in what we practice. We don't do general real estate. We're not pretending to be attorneys that practice in this area because we happen to throw it up on our website. This is what we do. All 21 attorneys within our firm, day in, day out. So if you've got any questions, we'd welcome you to reach out specifically to me or frankly to any of the other attorneys in the firm. You would need a representation agreement in place if we're going to look at your governing documents. But as Jeff mentioned, a lot of what we're talking about here today is based on Florida law and the Florida statutes, not specifically your documents. The other thing I'll mention is when you're putting in the Q&A, I'm going to ask that you keep it directed to what is in your governing documents, not your set, but what goes into, the governing documents, and how the Florida statutes and Florida case law might interplay with that. We're not talking about the responsibilities of the board today. That's what a board cert class is for. We're not talking about general covenant enforcement. That's what our covenant enforcement class is for. If you want that information, I do welcome you to check out our website at kbrlegal.com, go into the resources tab. And I think Jeff already has up even my class that I taught on Tuesday of this week. We've got a ton of videos. We've got a ton of articles between Jeff Rembaum's Roundup and that's Robert Kaye's Legal Morsels. But more importantly, for purposes of what we're talking about, we've got all the videos that Jeff's showing you now. So we've got a ton of resources. All of it is free. I welcome you to check it out. And now let's get started, now that I've taken up a couple minutes talking about the firm and the resources we offer for free, because we really do think education is extremely important. So now on to the actual education. The first substantive slide here. So we're looking at the hierarchy of your governing documents of your community, whether you're in a condo, a co-op, or an HOA. The only difference here between a condo and a co-op is going to be that rather than a declaration of condominium, which is it's basically the constitution of your community, you're going to have a proprietary lease. That's really the difference for the most part, other than how the community is owned, whether it's by the owners, by the shareholders, by the community itself. So in a condo, the order of importance is exactly what's shown here. Pardon me. In an HOA, it's exactly the same. The only difference is that you're looking at a declaration of condominium versus a declaration of covenants and restrictions. You might have easements in there as well, whatever you want to call it, but that's your declaration, your CC&Rs. Okay, that's the document that's basically going to say, here is how the community operates on a day-to-day basis. This is the restrictions. Here's what you can and can't do in the community, etc. And this is why it's important to understand which document we're dealing with, because we want to understand, well, which one should we be looking at when we're trying to figure out the answer to a question? Or more importantly, which one should your attorney be looking at? And if they don't know that, that's a problem. But moving on, the declaration is basically going to be presumed valid. Anything that's in there is presumed valid and enforceable by a court, unless there's case law or Florida statute that says you can't do that, or there's a federal statute that says you can't do that. And that's really the subject matter of most of the slides here today, is what you can't do. I know that doesn't sound fun, but it's important information to know, and we'll get into some of the more fun stuff and some of the changes that you can make to help your community a little bit later on. The next document in line of importance and priority, and when I say priority, what I mean is if there's a conflict here between the declaration and the articles, the declaration controls. If there's a conflict between the bylaws and the declaration controls. If there's a conflict between the articles and the bylaws are going to control. So you're just going down the line in order of importance based on what's listed here. So your articles of incorporation are basically the document that says this is the name of the corporation. This is how it operates in a very, very general sense. Here are the original officers. Here's the purpose of the organization, which is basically to run a community association. Then you've got your bylaws. Now that is the true procedural manual for your community. Now that's different from policies and procedures that are adopted after the fact or separately. So we'll get into that later. But when I say your procedure manual, it's going to say how your elections are run. It's going to say how your officers are decided upon, who they are, what their responsibilities are, who can and can't be an officer, who can and can't be a director on the board of directors elected by the members. By the way, board of directors is elected by the members, which is the owners. Officers are elected by the board of directors. So don't think that there is a board president. There is a member of the board who happens to be a president, but those are not necessarily the same people. And then finally, the most scrutiny that a court is going to ever look at your governing documents is going to be your board-made rules, your regulations, maintenance standards, policies, architectural criteria, your policies and procedures, and things of that nature. So these are all of the documents that you might have in what I call your governing doc book. So when I bring in a new client to the Orlando office of the firm, the first thing we do is pull all of the documents we can find on the county public records that pertain to your community. We're not talking about mortgage foreclosures and things like that, but your declaration, bylaws, articles, all the amendments, and any other recorded easements, deeds, plats, things of that nature. Okay. These are all things that are going to go in there. So again, look at the order of what's listed here. You'll have these slides later. That is likewise the order of importance and of scrutiny. Actually, it's reverse order of scrutiny that a judge is going to look at if a judge is trying to interpret these governing documents. So moving forward, the amendment process. What the heck are we doing if we think that there's something in our governing documents that really doesn't make sense or that could be better? Now, as an initial point on the left here, we have the fact that Florida case law imposes a 5-year statute of limitation on challenges to recorded amendments. I have succeeded in validating invalid amendments in the past because no one challenged it in 5 years. Okay. Someone challenged it 15 years later in the most recent instance. My response was, Judge, This has been in the county public records for 15 years. It's too late to challenge it now as being invalid or unenforceable. The judge said, you're absolutely right, Alan, you win. So that is one important thing to keep in mind. And especially when we get down to the bottom of this slide and get to mortgagee approval and things of that nature, if someone comes back to try and challenge this way later because they finally found out about it, it's been in the county public record since the day it was recorded. That's part of why we record these governing documents in the county public records, because that places everyone on notice of what's in those governing documents. And when I say everyone, I mean literally the entire world is considered to know everything that's in the public record. That's not actual knowledge, but it's called constructive knowledge. Okay, it's called constructive notice, to be more specific. So the process of adopting an amendment, meeting versus written approval, these are two options. Now let's go back a little bit, because first you need to decide what the heck you want to put in here. Okay, then you're going to have most likely your attorney draft it. The board's going to go back and forth and say, this is what we want, this language should be changed, or we want this to be a little bit more specific. Then you're going to finally have the board approve it. That doesn't necessarily have to happen at a board meeting, but it might. Then finally, once the document itself, the proposed changes, are approved by the board to send out to the members, you can either hold a meeting where the members will get to vote on it. A lot of times that just coincides with the annual election meeting because the members are already meeting together, versus you could have just a written approval. You have a bunch of people sign consent forms, you compile them all together, and then all of a sudden you've got your percentage, whatever the governing documents require in order to have that amendment. Okay. If you are having a meeting, you might have proxy forms that are similar to that written approval. You're basically signing a document that says, this person can vote on my behalf. If I didn't specify who that person is, the secretary gets to vote on my behalf on each one of these amendments. Then you're going to distribute it to the members, all of the amendment, the proxy form, and any written ballot that you might be trying to accomplish. You're going to hand it all off. And when you have your meeting, you're going to tally the votes. Now, if you're not doing it via a meeting, you can get that written approval and count those votes at any time as soon as you've got the votes in. So when you do a written approval instead of an actual meeting, really what you're trying to do is get the percentage that is required in order to accomplish the amendment. Now, one thing that I'll suggest as the first amendment you might consider, because a lot of governing documents will say you need 2/3 of the entire membership or 75% of the entire membership. And those are the percentages for HOAs and condos respectively. If your governing documents don't say what percentage of the members need to vote. And when I say percentage of the members, I don't mean the percentage of people that show up. I mean the entire community. So this can be really difficult. So again, the first thing that you might consider is before you even try and pass any substantive amendments, amend the amendment provision and amend the quorum provision so that all you need is a majority of a quorum. Quorum is basically usually a simple majority of the members. Sometimes it's less depending on your documents. So what you could do is say at least 30% of the members need to show up either in person or by proxy and vote on these amendments in order for them to be potentially valid. And then at least a majority of the people that do show up need to vote in favor of it. And that way you might need 16% of your members versus 75% that's currently in there. Now, keep in mind, you still have to get that 75% vote at least once, but at least you might not have to get it every single time you're going back to make an amendment. Okay, so let's get into material amendments. You can have major changes. You can have minor changes. You can have changes to the specific and I think this refers in the notes, because keep in mind, this is a seminar that our firm has been putting on for a while now, but I have a feeling, and I will explain it this way, regardless of what it was intended or not, that the material amendments refers to material alterations, which is something we'll get into later. But that is basically when you're changing the appearance of either the community, a lot, or a unit. Usually in an HOA, the association is allowed to just go ahead and make those changes. If not, it might say in your governing documents, and it most likely will say in a condo, that the percentage vote required is the percentage vote required to make those changes to the appearance of the building, to the appearance of the community as a whole, will generally be the same percentage that's required to amend the governing documents. That's another provision that you might want to change, even in a condo, so that you do have an easier right of making those changes. And we'll get into some ways around that later. Termination's another one you might want to amend to make it either harder or easier to terminate the condominium, depending on what you want to do. Leasing and rentals are big ones that we have an entire class about. It's called the guest restrictions class. You might want to check that one out online on our website, like I mentioned earlier. Suspension of voting rights is another one. There's case law that came out that basically said you might not be able to suspend voting rights at all unless it's in your governing documents that you have that authority, regardless of whether a statute was put in place that allows that. And we will get into the reason for that in a minute when I talk about what's called Kaufman language. And then there's also mortgagee approval. Most governing documents will say that all lenders in the community actually need to approve every amendment. There have been changes to the statute that basically say now you only need to get that lender approval or even seek it if the amendment would actually impact the lender's rights. What that means is if you're talking about someone having to get approval from an architectural committee to make changes to their lot, the appearance of their lot, things of that nature, that doesn't have any impact on someone who lent money, their ability to collect that money. So that's not something you need to run by the lender. And the legislature actually did something right on that one. They basically said you shouldn't have to run that by the lender. It has zero impact on the mortgage. But if you're changing the provision, like we'll discuss in a minute, about what happens when a lender forecloses, what does that entity or that person that buys the property after the foreclosure sale owe the association for past due assessments? That's something that substantively impacts the lender. So when you are doing these amendments, another thing that your attorney should be explaining to you is whether or not you have to get lender approval for the amendment. And if that is required, keep in mind, all you really need to do is figure out who the lenders are, where to mail notices, and whether to mail them. Because some people will just take the risk that a lender is going to challenge it later. We'll talk in a minute about some things you can do to make it so that you don't need to send out that notice, even though you're impacting future lenders' rights. Okay, so moving forward, some common misconceptions. That's the bulk of our seminar today, or at least the materials, but I'm going to go through some other things, like I said, to bring it back around to the initial title that you probably were expecting to hear about today. What provisions are illegal? Well, there are provisions relating to race. You can't say, or religion, age, sex, sexual orientation in some locations. Those are all prohibited provisions under the Fair Housing Act and various other laws. Now, there are Florida and federal laws governing things like this. And I mentioned fair housing, and I mentioned these discriminatory processes and discriminatory provisions. Just understand that's an example. There are a lot of provisions that can go in governing documents that are not allowed under Florida law or under federal law. So you're going to want to run every potential amendment by your attorney, even if the attorney is not the one that's preparing these amendments. This is something that our firm does, and I personally work on pretty much every day, is an amendment to some set of governing documents. So make sure that you've got someone well-versed in how to properly draft these governing documents if you are working with an attorney on some changes to yours. What provisions are holding you back or costing you money? We'll talk about that in just a minute. Moving forward. So here is one misconception. A foreclosing lender is automatically required to pay 1% of the original mortgage debt or 12 months of unpaid assessments after they take title if they name the association in their foreclosure action. Well, unfortunately, that's not accurate. That's the statutory safe harbor. But, and this is where we talk about that Kaufman language I mentioned a moment ago, your governing documents might contain language, and I will say most governing documents do, that says mortgagees, lenders, actually get a lot bigger protection than what's under the statute. The typical provision, which I call it a subordination clause, it basically says that a lender that forecloses and takes title doesn't pay anything to the association if they acquire title at the foreclosure sale or via deed in lieu of foreclosure. Keep in mind, I'm talking about the lender right now. This might include, depending on the language in the governing documents, a third party that takes ownership through that foreclosure sale, meaning it wasn't the lender, it wasn't the association, it wasn't the owner paying off, it was just some random person that came in and bid at the foreclosure sale. Okay, that person might not owe a penny. So you need to do an analysis of, is this a provision that changes a substantive right. What we're talking about here is the right of the lender under your declaration that they are relying upon to lend money. Are you trying to amend your governing documents to impact and reduce their right to not have to pay anything after they foreclose, which might in turn impact their willingness to lend money in the first place? Because if they know that they're going to owe all the assessments jointly and severally with the owner who didn't pay them and also obviously wasn't paying you, they might not lend the money in the first place. However, one way to get around some of this, again, this would risk a lender being less willing to lend money. You might incorporate that 1% or 12 months that's currently in the statute into your governing documents. You do an amendment. I have one community right now that's working on it. This would be one that generally requires lender approval. There are two different ways to do it. One, you don't get the lender approval. You take bad legal advice. You don't spend the time and the money to find out who the lenders are, get their approval before you pass this amendment, but you acknowledge any mortgage that was given before this date of this amendment, before it was recorded, won't have to pay those assessments. You're going to use the previous provision when they foreclose. The alternative, and from my perspective, the right way to do it, even if it's not a better way to do it, would be to expressly say in this amendment, this is not going to affect any lender who lent the money and whose mortgage was recorded before the date of the amendment. At that point, you're not impacting anyone's substantive rights because those rights didn't exist until after you amended the documents. Okay. Now, procedural changes to the Florida statutes generally will kick in regardless of what language is in your governing documents, and they will generally control over the governing documents unless the statute says, and it'll usually say exactly this, unless otherwise stated in the bylaws or unless otherwise stated in the governing documents. Now, the language that we're looking for to adopt all future changes to the statutes, which you might also adopt, but isn't always a great idea, is language that says we are operating under the Florida statutes governing HOAs, governing condos, as amended from time to time. That's what we call Kaufman language. Now, here's why that's not always a good idea. You might want the newest and greatest statutes to apply to your community, but the newest isn't always the greatest. Okay, we've seen in condo land over the last few years some of the messes that the Florida legislature can cause. You don't necessarily want all that incorporated. You might want a choice as to what's incorporated or not into your governing documents. Okay, so that's one thing to consider. It's an option to adopt what that Kaufman language might be and amend your governing documents so that future amendments to the statutes are incorporated. You might not want that. So that is something that the board would need to make a business decision as to whether or not that's a good idea. I would almost never actively recommend it to a client, but I'll happily give guidance on it if someone asks about it. Moving on, landscape grass lawns must cover the bulk of the front yards in our HOA. That might be in your governing documents, but there is a law saying that Florida-friendly landscaping must be allowed. Now, here's the thing. No one knows what the hell Florida-friendly landscaping actually is. The bottom line, I don't know of an attorney who's been able to give me a decent definition of what that means. But the bottom line is it's basically allowing people to put stones and xeriscaping into their front yards instead of landscaping, grass, and things of that nature. So if you've got architectural criteria, maintenance standards that would require that landscape grass lawn to cover almost the entire front yard, that may not be enforceable if the owner claims and is able to show that their landscaping is more Florida friendly. Again, whatever that means. Moving along, the board has sole decision-making power when it comes to filing lawsuits. Well, yes, they get to decide whether the lawsuit gets filed in the first place, but there is a section in HOA land, this does not exist in condos or co-ops, but this 720.30751B basically says that even if the declaration contains a provision, which it shouldn't, prohibiting the association from suing the developer, you can sue the developer. And the Florida legislature also prohibits commencing litigation against any party where the amount in controversy exceeds $100,000 unless the members vote to authorize that action. Now, with respect to that first one, yeah, you can't have a provision that says you can't sue the developer because guess who created these documents in the first place? the developer. You can't create a document that says you can't sue me. That's bad business practice, at least for the association. So that's not allowed, period. This needing authority from the members, keep in mind that is intended as a shield for the members, not a sword to be used by some non-member. So if you're suing your developer, you're suing someone that did construction and did a $5 million job and screwed it all up, that's not something that they can really use to get your case kicked out of court and dismissed. But you will have to go back to the members and get the vote after the fact if you filed the lawsuit before doing it. Bottom line, before you file that lawsuit, get the approval. You know what your damages are going to be. The only reason that I would suggest maybe not doing that is if you're talking about a construction defect and you're at the last minute before the statute of limitations runs, and you would lose your right to file that lawsuit. Basically, in an emergency situation where you can't get the member vote in time after you found out that you have to file this lawsuit. Another one, and again, this is, check out our guest restrictions class. There's a lot more that goes into this. All new owners go through the screening process in our community. Wrong. See a fact pattern here? Many of the mortgagee protection clauses, not only do they limit what the lender owes after they foreclose, but they also say that the lender or the third party that buys the property at the foreclosure sale doesn't need to get approval from the association before they put someone in the property or before they own the property. So even if you've got screening rights, that might not apply depending on who's in there. They might not also apply to, someone who takes the property via will, or a deed that doesn't include consideration. Basically, they were gifted the property. So keep in mind, you're going to want to look closely, or more accurately, have your attorney look closely at the language that's actually in those documents. That might be something that you no longer want to have in there, and you might want to change it so that everyone has to get screened, except for those lenders, or like I mentioned earlier, future lenders. Now, look at the words carefully. Does it say purchaser or buyer? Or does it say transferee? Those are all different terms, and your attorney should know the difference. What are your responsibilities with respect to screening? Does the association have screening rights? What are you allowed to look at, which is limited? I won't get into that in detail because it doesn't go into the governing documents. But again, check out our guest restrictions class if you want a little bit more information about these issues. Moving on, once the law changes, the change is automatically applicable to your community. Wrong. We talked about Kaufman language before. That's the analysis you're going to have to do here. Does it apply or not? It'll apply generally if the new law is procedural or remedial in nature. In other words, you've got a new penalty you can apply that wasn't in the previous statute. But it can't change a fundamental contract right unless there's a compelling public policy need. Okay, that compelling public policy need, in my opinion, is the only reason that the legislature was allowed to put in place all the restrictions it did in the last 2 years, requiring community associations to add mandatory reserves. I would say that is a substantive change in the way that the association is required to operate. It's not a procedural change. It's not remedial. So the public policy reason, which by the way was because of the desire to avoid a second building collapse like what happened in Surfside, Florida, I think was it 2020 or 21? So you got to keep in mind, is this a procedural or substantive change? Does the governing documents does the declaration contain that Kaufman language saying we're incorporating the Condominium Act as amended from time to time? Or does it just say we're incorporating the Condominium Act? Because keep in mind, and I don't think I mentioned this yet today, but I've mentioned it in the last 3 webinars I've done in the last week, that the bottom line, and I know I've used that phrase a lot, but it's accurate when we're talking about a lot of this, the governing documents need to contain language that clarifies whether we're talking about the Condominium Act, which is the Condominium Act as it existed when the declaration was recorded, if that as amended from time to time language is not included in your declaration. So we're either looking at the statute now or the statute when the declaration was recorded. And the determining factors are procedural versus substantive. What was the change in the statute? And then in turn, what is the language in the governing documents? Are we talking about the original statute that was in place when the declaration was recorded or the current one? Another one, residents are prohibited from having clotheslines in your HOA. Okay, it's great if it's in the declaration, but it's not enforceable. Now you can prohibit the location of an energy saving device based on renewable resources. That includes clotheslines, solar panels, but you're gonna have to allow those energy saving devices. And clotheslines, believe it or not, are considered an energy saving device. Another thing that people don't understand that they must allow are solar panels and skylights, even on condo roofs that the association maintains. You can put in restrictions as to where they're located. You can put in restrictions as to what guarantees the owner needs to provide before they're allowed to put it in, meaning, are they going to take responsibility for if the roof needs to be repaired, ensuring that that part of it is covered by them and not by the association, that it won't damage the roof and cause leaks and things of that nature. You can require those guarantees, but you can't tell someone they can't have these energy saving devices. And when I say, by the way, with respect to the location of these energy saving devices, and also satellite dishes is another one. You can tell people where they can place them, but you must allow them, and you must allow them in a location where that device is actually going to function for its intended purpose. So you can't tell someone you can have the satellite dish or you can have the solar panels, but you have to put it in the dark where it's not going to gather any light or it's not going to get a radio signal. Okay, you can't tell them you need to put it in your garage. That's not going to work. Moving forward, our community can enforce rules prohibiting minors from using any of the recreational facilities without an adult present. Nope, that's a fair housing violation. You can't discriminate against families with children. You can't discriminate against children. So the way that your rules and regulations need to be stated is so that someone that doesn't meet a certain criteria that is different from age can't use the facilities. Okay, so you can say there will be no diapers in the pool, but you can't say babies can't be in the pool. Moving on, and by the way, that is one of two major issues where even if you win, you lose when it comes to a lawsuit, because you're not going to recover your attorney's fees and costs unless you can actually demonstrate that the other side filed a completely frivolous lawsuit. And bottom line, I've seen that happen twice in a 15-year career. So just expect that you're going to be out a bunch of attorney's fees and costs when that type of thing starts to happen.
Hey,
Jeff,
Alan,
jump in.
How does something like that apply? What you just mentioned, like the younger people using facilities, for instance, in a 55 and over environment.
Well, generally speaking, you probably can't keep younger people out of using the facilities, but in a 55 and over, you can control who's allowed to own and who's allowed to reside within the community. But I haven't seen anything where it was allowed, where the association was allowed to say you can't have visitors under the age of 55. That
Right.
just, you're basically telling people, please don't live here.
Yeah, your grandkids can't come and visit. I got you.
Right. So, when you talk about jumping into the clubhouse, from my perspective, that's no different from saying no one under the age of 55 can come to my home. So good question, but I just don't see that as a valid restriction, whether it's in the rules and regs or elsewhere. Next one, the board must obtain a vote of the owners before making material alterations. Nope, we discussed this one earlier. In the HOA context, there is no restriction on material alterations unless the governing documents say so. Where you're most likely going to see this limitation in an HOA is where you've got a provision that says that the board spends $10,000 or more, that requires member approval, unless it's just a maintenance issue. So that's one thing. And then in a condo context, keep in mind that your governing documents will generally say, and if not, there might be a statute on point. I candidly don't know that one offhand, but generally speaking, in a condo, the members do get to approve whether or not changes are being made to the appearance of the community. Now, notice this second point here, necessary maintenance exception. There's a case, which I believe was Seagate, that basically says if you are making changes to the appearance of the community, but it is for purposes of protecting or necessary maintenance. In that case, it was a rock revetment wall, which is basically where you have, it's the easiest description is You've got something that's blocking water from coming up onto the community. If you're in a canal, a lake, any kind of waterway adjacent to the community, you're trying to block that from coming onto sidewalks, driveways, into properties and things like that. So that rock revetment wall was not approved by the members of this condominium, but it didn't need to be in the court's estimation and in the opinion of the court, specifically because it was intended to protect the association from damage. So if you are doing something that is a necessary maintenance and you can't get the materials that were previously in place, or if you are doing something that is to protect the association, chances are that even if there is a requirement for approval by the members, it will not apply in that instance. Moving forward, delinquent assessments accrue interest at the rate of 18% and a $25 late fee applies. That might be true, might not. So the Florida statutes governing collection of past due assessments all require that the authority to charge a late fee is included in the governing documents. That's generally the declaration or bylaws. Now, it's not just a $25 late fee, and it's not a $25 late fee per month. It's $25 or 5% of the installment, whichever is greater, and whatever is in your governing documents per installment. So if you do quarterly assessments in your community, you do not charge $25 a month. You charge $25 a quarter if that's in your governing documents, or 5% of that quarterly installment. With respect to the interest, yes, the statutory rate is 18%. You do automatically have the ability to charge interest, but look at your governing documents because they might say that you have 10% interest. You might need an amendment to change that to 18%. So be careful with the interest rate you charge. Also, you can't charge interest on interest. You can't charge interest on late fees. You can't charge interest on attorney's fees and costs. You're only charging interest on the assessment itself. And it's not a per month accrual like a late fee. It's a per diem, per day. So you charge interest based on the amount of days since each assessment installment accrued. So you've got, if you're monthly, you've got interest on January's assessment, separate interest on February's assessment, from the date that that assessment accrued until today's date, if someone wants to pay you off late. The other thing that's not mentioned here that you'll want to look at in your governing documents is when do these things accrue? Because it's not automatically you paid late, so you owe interest. A lot of your governing documents will say the interest and the late fees accrue on the 11th day after the payment was due, or after 30 days elapses without payment. So just be careful as to when that accrues, not only whether it accrues. Next one, a pipe and a wall serving one unit is a maintenance responsibility of that owner. Well, that might be true. It might not. Depends on your governing documents. So you're going to want to read the declaration of condominium, or again, more likely have your attorney do that and determine the boundaries of the unit versus what is a common element in your community. All right, moving on. What have we learned? A bunch of stuff. Okay, but here's the thing. We haven't really gone through a ton of changes to your governing documents. So here's a couple things that I will suggest. We've talked about a few of those. Now, we'll also talk about some of the stuff that's on this slide. Okay, safe harbor and mortgagee liability. We talked about potentially amending your governing documents and having that amendment apply only prospectively, not retroactively. Meaning, if the lender gave the mortgage, but the mortgage foreclosure happens after, so pre-existing mortgage, post-amendment foreclosure, you would not apply this change to that lender because that would be an impediment of an existing contract, which is the mortgage. You've got architectural guidelines and requirements. Those need to account for renewable resources. They also need to be supported by your governing documents. So if your declaration doesn't allow you to adopt architectural guidelines, or if it says you can adopt architectural guidelines, but it's completely unclear, just understand the statutes are pretty clear, and this is mostly in an HOA world, but the statutes are fairly clear that those restrictions on the way you can use your property need to be clearly inferred, or I'm sorry, clearly stated or reasonably inferred from those architectural criteria in order to be enforceable. So make sure that you are fairly clear in what you're allowing and restricting, not just if you want to have a fence, you got to ask the association. That's usually what I find in governing documents. But it doesn't say this is how high a fence can be or must be. It doesn't say these are the materials the fence need to be composed of. It doesn't say this is the color of the fence we want. You don't have a color palette for the homes. Okay, these are the types of things that you'll want to have in architectural criteria. Powers that are in the governing documents may be there, but may not be enforceable because they're limited by statute or case law. Run it by your attorney. You may be losing money on interest and late fees that you're not charging or that you don't have in your governing documents but could add. Keep in mind, yes, this is a penalty, but it's only a penalty against people that aren't paying on time. So keep that in mind. Rights of first refusal are different than rights of approval when we're talking about transfers of property. The fact that you have the right to buy the property if you don't like the person or the offer that's being made from that person doesn't mean that you get to approve or disapprove that person. It means that the association might be able to step in and buy it. And if you have a right of first refusal, that also doesn't mean that you have a right to screen people coming in. It just means that you get to see the offer and match it. New laws, like we discussed, may not apply to your association due to limiting language in your governing documents. So again, it's not always a good idea, but the thing to consider there is whether to incorporate all changes to the Florida statutes automatically going forward. And then old language in documents and rules expose the association to discrimination claims. I was very proud. I think it was about 2 years ago, 3 years ago, I actually amended out a provision in a set of governing documents in Central Florida that said there shall be no Jews or blacks in our community. Don't really think we want that in there anymore. Don't think it ever should have been in there, but it was. So the bottom line is that would not be enforceable now anyway, but do you really want to live in a community that technically has that restriction? Because I sure as hell don't. Frankly, according to the documents, I can't live there. So these are just some considerations. A couple more that I'll add, and then we'll get into the Q&A. There's a new chapter, 720.3045. This is when you can't amend around, but I really hope someone challenges it as unconstitutional. This is HOA land only, but this is the statute that was passed in July of this year that basically says any improvement, meaning something, an item that was added to the backyard or added that you can't see. And I say improvement, but that includes boats, RVs, trailers being stored out of sight, anything that your governing documents restrict, meaning it's a violation, but which isn't visible from the frontage of the lot or from an adjacent lot, is no longer enforceable under Florida law. Now, we talked earlier about how it is a violation, a constitutional violation, to impede contract rights. And in my opinion, this legislation is impeding existing restrictions on its face. It's expressly saying, regardless of what your governing documents say. In other words, we know that there are communities that have restricted this stuff since the 1960s, but we're going to say that it's no longer enforceable in 2023. So this almost 65-year-old provision of your governing documents just disappears. I hope someone challenges this as unconstitutional. I don't know of many community associations that want to spend the hundreds of thousands of dollars to take it up to the Florida Supreme Court. So I don't see it happening, but I am one of several attorneys in our firm and in general in Florida that are trying to get it overturned. But bottom line, that's not one you can do anything about. It's one I want you to be aware of. And then an amendment or two amendments that I am suggesting to most of our clients at this point. There's case law that came out in 2022 and another case that came out about 2.5 months ago as of this recording. And they basically say that regardless of the risk of someone that you are going onto their roof to cure a covenant violation, shooting your vendor in the face, verbally assaulting them, hurting them physically in some other way, that risk is too speculative to say we have the right to go onto their property, but we're not going to use it. So that's called self-help. And it's essentially where your governing documents will say, if an owner fails to cure a violation, the association can go onto the property. And here's the thing, I said can, not must. The courts are now interpreting that as must anyway. must go onto the property and resolve the violation. And the reason for that is that the courts view that as an adequate remedy at law, meaning you can't get an injunction. You file your lawsuit for an injunction, which is what you normally do when you're enforcing your covenants, forcing the owners to actually cure the violation. And the judge says, if the owner argues against it and says, no, judge, they have self-help rights, the judge would be obligated to say, you know what? You're right. They have self-help rights. Hopefully the judge would be wise enough to ignore these cases and say, it makes no sense to put someone at that kind of risk just to address a covenant violation. But what I'm recommending to a lot of communities, and I'm working on 5 or 6 of these right now, is to remove the language from the governing documents, actually amend to have less rights to do this stuff that you're not going to do anyway, because you're not going to put your vendors at risk. You're also not going to go onto a property and install screening material for a water pump next to the garage, because you don't know if you're going to dig down and end up cutting a utility line. Okay, so things of that nature. These are all risks that the courts about 2.5 months ago expressly found to be insufficient to justify not using this remedy. So just amend it out. If you're going to pull weeds, fine, leave that in, but amend everything else out. And finally, the last one that I will suggest is, again, regarding covenant enforcement. If you've got owners that are violating your covenants, you file your lawsuit, chances are your governing documents say the association is entitled to recover its reasonable attorney's fees and costs as the prevailing party in that type of lawsuit. Well, what if you spend $2,000 going through the entire process, going through mediation, but not yet filing a lawsuit, and then the owner cures? That's a nice $2,000 cost of doing business. So what I'm suggesting to a lot of my clients, and this is another one I'm working on 4 or 5 of these right now, is go back into your governing documents, and if it's not already in there this way, which it probably is not, unless someone like me already did this amendment, go into the governing documents, try and amend them so that they now say that the individual who caused the problem is responsible for those fees and costs, regardless of whether or not a lawsuit is filed. Meaning you go through that $2,000 expense to get them to comply, they comply, you can still go after them, even though no lawsuit's been filed, for just the damages associated with that. You can recover your attorney's fees and costs. And better yet, the way that I suggest doing that is that you are sending them, let's say, a 30-day notice that those attorney's fees and costs were incurred. You appreciate them complying after you sent out 5 notices, because chances are the association sent 3, the attorney sent 2. You appreciate them complying. Here are the attorney's fees and costs that were incurred in the covenant enforcement process. They are due, and if they are not paid within 30 days, they become an assessment against that lot or that unit. Okay, that really keeps the person or the individuals or the lot or unit that caused the problem, make them responsible for paying the attorney's fees and costs. And if they don't, they won't own that unit or lot anymore. Instead of just leaving the entire membership responsible for problems that are being caused by 1 or 2 people. So with that, I thank you all for attending today. That's the substantive presentation. And now we'll open it up. I know we've got some Q&A in there, but so can the rules restrict allowing shutters to be used during the summer versus only when there is a named storm? Yes, absolutely. That's the answer to that one. Moving on.
This one makes little sense to me unless it's a motorized bike.
Can you restrict someone from taking their bicycle inside the building to their unit during the year? Yeah, I'm not quite sure why you would need to do that. As long as they're not leaving the bike out in the hallways and in the way that's blocking access to other units or common elements.
What if someone's dragging in a bike after going on a mud trail, dirtying the hallway? Can that be addressed?
Yeah. So that's what I was about to actually say. Good point, Jeff, but no, that's fine. I'm glad we're on the same page as usual. You can't restrict them from doing that, but you can force them to either clean it up or pay for the cost of cleanup. Now, the problem is, how do you determine who's actually doing it unless you've only got one person dragging their bike through? Hopefully the trail of muck is going to lead directly to that unit. But if not, then hopefully you've got some cameras that, by the way, are not pointed directly at any unit doors, because that might be a violation of privacy.
Yes.
But that would be my answer. Can we restrict satellite dishes in a high-rise condo? Yes, but only as to location, and only as to a location that it's still going to actually function properly. You can't require that satellite dishes be placed in a location that won't actually give them full service. Moving on, I'm concerned we have amendments that we may have lost track of. Can we get copies of all our amendments filed with the county? There's two ways of doing that. One, go on the county public records and search for them. If they were filed and recorded with the county, they're going to be accessible. You can just go to your county public records website, the official records of that county, and search for the community name. That should locate it. The alternative, and frankly, the one I prefer, is you sign a representation agreement with me. We pull your governing documents as the first step in working with you. And we will get you a copy of literally everything that is recorded, like I said, in the county public records affiliated with your community. Can the association turn off someone's cable and internet if they're in arrears? Now, I let this one slide. It's not really relevant to what we're talking about today, but I think it's important enough for everyone to understand. There is an absolute questionable answer there, because it depends whether a judge or an arbitrator would decide that that cable and internet is actually something that is a utility. Some say yes, some say no. Arbitrators will differ. I haven't seen a judge rule on that issue, but you can't shut off any utilities in a condo. I think it's probably okay, but you are taking a risk. Yes, Mr. Solomon.
Thank you for calling on me. You know, when I was part of the management team where I was working several years ago, that is something that even if folks were in the rears, it's something to think, even if you are permitted to do something like that, like if you're on a bulk agreement or something, I'm not sure that's something you want to get your association into, because that is something that people rely on for emergency situations, such as if there's a storm coming or if there's an imminent threat, a terrorist, or whatever it is. That's how people, that's how people receive emergency information. And I'm guessing you can get the association in hot water if you cut off, even if that's something you're permitted to do. Just because somebody's
bottom line, I don't
storm, you know what I mean?
Yeah, I would say it's probably not worth the risk. What I would suggest instead is, if you've got a gate, shut off the key fobs, things of that nature. Shut off the fob or the access to the pool, the gym, whatever other amenities. But this one is so heavily used by literally everyone, and for a lot of people, crucial to their daily work. People are working from home more frequently, and they're going to argue that either they weren't able to work, and so you should pay them for the cost of their daily salary while it was shut off, even though I think that's a garbage argument, and that is a legal term, garbage argument. Or they're going to sue you for loss of a deal that they claim they couldn't make because they couldn't jump on their computer because they didn't have internet. They're a real estate agent, and they lost the deal because they couldn't get a contract out because their system sucks and they don't have the ability to do that from a tablet or a phone. So moving along, I think, Jeff, you're on the right page there, on the right track. I think it's too much of a risk to be worth it, but there are other alternatives that I would be happy to suggest, one of which is shut off the key fobs if you've got a guard gate. We're a 550 unit HOA. It is so hard to get a quorum for general meetings, etc. Any ideas or suggestions? This is something I deal with fairly frequently, because I do represent a bunch of, I represent one that's 3,000 lots. Start with electronic voting. That might be something that would help you. Especially if you've got members who don't live locally, if you can get them to sign up for electronic voting once, they will vote at every meeting of the membership from that date forward, because it's easy. You go on your phone and you click through. The other thing that I will suggest is a suggestion I made earlier. Try and get the one vote to amend the governing documents to make future amendments easier. That's something that I do. I won't say all the time, but it's with some frequency, maybe one every 2 to 3 months, where a community really nice Fat Tuesday cup, by the way, Jeff.
water. That's water.
I wasn't saying what was in it. Where the community wants to make it easier to adopt, a more substantive change. Some people that are not willing to vote on substantive changes are still willing to vote because it's an easy decision. Yes, we want the community and incorporate into the mailer a letter from counsel explaining why this is a crucial thing to do. We want to make sure that we can keep our community up to date with law. That's why you're on this class today. We want to make sure to keep our community documents up to date. That's the way you explain it. Does the law require document amendments to be written by an attorney? No, but I'd recommend it. So an attorney doesn't have to draft these changes, but in order to do it in a way that's most likely to actually be enforceable, not conflict with your other governing documents, and be done in the format that's required, I do recommend that the attorney draft it. And when I say I recommend the attorney draft it, that doesn't mean I recommend you draft it and send it to the attorney to fix up, because I'll be candid, that usually takes a lot longer to make changes to what the association did than to have the association say, this is what we want to accomplish, and let the attorney draft it the best way. Can an HOA add an amendment to charge a capital contribution to new owners? Yes. And you can also put in there that the board from time to time gets to decide what the amount of that capital contribution may be, rather than having to amend every time you want to change the dollar figure. Because I see a lot of them that it's like $50 and they want it to be $2,000. If you have it in there that it's $50, it's $50 until you amend. So to not have to get that member vote every single time you want to change the dollar figure, I suggest having it in there that the board has the discretion to decide from time to time what the dollar figure will be. Next question, what's the percentage of owners that need to approve the changes to the governing documents, or does that depend on the documents? Document dependent in almost every instance. I've never seen a set of governing documents that doesn't specify the vote that's required in order to accomplish an amendment to that document. However, keep in mind, there is entirely feasible outcome where you don't have that. In that event, you're going to look to the statutes. It's different for condos and HOAs. I think it's 2/3 in an HOA and 75% in a condo and a co-op is the default amendment percentage. But don't quote me on that specific percentage. Billy Stevens, how you doing? Good to hear from you. Is a change in a fee structure for violations a material amendment in the rules and regulations? So that is not, in my opinion, a material amendment. That's something that's going to go, it's going to be a board-made rule as long as the violations are the fines are authorized or the costs are authorized in the other governing documents. So you have to have the authority to actually change the dollar figure. If not, it defaults to the statutory $100 per violation up to $1,000. And in an HOA like Billy's HOA, that can become a lien against real property only if the governing documents say so. Again, Billy, do rules and regulation amendments need to be recorded? So again, these are amendments to just your rules and regulations that the board makes. They don't have to be recorded, but in order for everyone and not just the members to be considered to know what's in those amended rules and regulations, in my opinion, they should be recorded. Because otherwise, the bottom line is, yes, the members are placed on notice because you've mailed it to them. It's in your official records. They're allowed to ask for copies of those rules and regulations. You might have it up on your website, but it might be behind login credentials. But the bottom line is, if you record it, everyone is considered to know about it based on constructive notice that I mentioned earlier. The only problem with recording those is that once it's recorded, every amendment after that needs to be recorded as well, because otherwise what's in the public records is what's going to control. Moving on, Laura, in delinquent assessment section, can you charge late fees on late fees? No, you cannot. However, and this goes a little bit beyond the class, but I'll answer anyway. The way that the statute applies all payments that are received for unpaid assessments is first to interest, then to late fees, then to attorney's fees, then to costs. So you can't charge late fees on late fees, but what you can do is continue charging interest on the assessment until the entire amount is paid. Moving on, our HOA is 55 and older, but a resident now has guardianship over grandchildren due to loss of parents. What can we do? Now, I don't know if Sandy, who's asking about this, is asking how do we get the grandchildren out or how do we help them? If you help them, you may lose your 55 and over status. So I hate to be blunt, and I hate to be, to sound callous or whatever, but that's what lawyers generally do. I've been told I have a better bedside manner than some. But the bottom line is you probably have to move to get those people out if your regulations don't allow them. The alternative is that some 55 and over communities require ownership by individuals who are 55 and older and allow residency by younger individuals. So that might be something that you need to amend your governing documents to accomplish, or you might just need to start the covenant enforcement process and say, I'm really sorry, but these young individuals are just prohibited from living here. A 55 and over community is one of the few places you actually can have age-based restrictions. Moving on, how important is it to have our declarations restated? I don't think they ever have been, except when the developer left. Now, that depends whether you're talking about amendments or you're talking about a full restructuring to update your governing documents. So when you say restated, that basically means you're taking all of the amendments, compiling them into one document and saying, this is a compilation of everything we had before. We're not making changes. We're just saying, here's what we've got in one single document. That makes it easier for your members, your board, your manager, and your attorney to review those documents. The alternative is, like I said a minute ago, we actually will do a process where we review the entire set of governing documents and say, we recommend changing this, 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 and this. And instead of just doing one set of amendments, we do it as an amended and restated set. So you're taking everything that was there before and doing away with it in favor of this brand new document that is an amended and restated declaration. That is something a lot of communities will look at and say, you know what, every 10 to 20 years, we should be doing it. And that is a process that I work on. I'd say every 2 to 3 months, I have a client that wants us to do that comprehensive review and revision process. More mundane update of documents. Can the original bylaws plus the amendments be created into one new doc? Well, what did I just say? Perfect timing for you to ask that question. It was right after the one where I answered that question. Yes, absolutely. And frankly, I recommend that if you've got a bunch of amendments, anything north of 3 amendments really should be an amended and restated version, because you don't, unless they are like one change like this in the amendment book, you really want to look at one document and not have to look at, okay, well, this is what the declaration says, but now I have to check all 3, and in some cases, all 9 amendments. I've actually had clients that had 12 amendments without a restatement. I don't understand that, because any attorney that's looking at that is wasting at least 20 minutes every time they review your governing documents to give you an answer. So you're actually saving attorney's fees by spending the money to do that type of compilation. If the community was created before 2007, can an HOA sue the developer for items not fixed at developer turnover? Most likely no. That's something that should have happened at turnover. It might depend candidly on when the turnover occurred. That's something, Clyde, if you'd like to discuss a little bit more in depth, I would suggest that we set up a meeting with me and our construction attorney, Jeff Green, who is the board certified construction attorney I mentioned earlier during today's presentation, so that we can kind of discuss that in a little more detail. It might depend on what specific problems exist, but the statute was changed just this year to limit that statute of repose. It was 20 years, then it was 10 years, and now it's only 7 years. So we're
Clyde says turnover was a year ago.
I'm sorry?
Clyde chimed in. He said turnover was a year ago.
It may be too late, but it's still worth having a quick consultation is what I'll call it. We don't charge for those unless you're already a client. And we might need to look at your governing documents in order to give answers, which would require an attorney-client relationship. But bottom line, I would suggest meeting with Jeff Green, whether it's with me or without. Moving on. What might
before Alan goes to the next question, there's 5 minutes left in the advertised time. So we're only going to get to as many questions as we can in that 5 minutes. So go ahead, Alan.
Thanks for that. What might it cost just to re-record the existing governing documents without any changes? I don't know why you would want or need to do that, but it's going to cost based on the amount of pages of those governing documents. That's really the only thing that I can say. It's usually just a couple dollars a page. I think it's maybe $4 a page. It might be even less. Plus, I think it's an $18.50 charge plus a couple dollars for recording digitally instead of sending a copy. So I just did, I think it was a 8 or 9 page amendment package with an amended and restated set of bylaws. And it was less than $90. But again, once the documents are recorded, unless they are so old that they're not available online, I don't really know why you'd want to record them again without any changes being made. So feel free to reach out to me if you'd like to, because we're not going to have time to get into it right now. But if you'd like to discuss the rationale behind the question, feel free to email me at as@kbrlegal.com. Monica, thank you for the kind words. Really appreciate it. She's just basically thanking us for the webinar. And thank you for being a client of our firm. Gary, related, if an HOA desires to update its documents, what's the quorum level that you recommend? I would say no less than 30%, because frankly, anything less than that, you're not really getting a consensus. But I think anything 30% or around that, I mean, some people will say 50. I think if you go down to 25, I really don't recommend going lower than that. Jan, our management company automatically gives themselves raises every year. In our original condo docs, there are several monthly requirements they're not completing. How can the condo make them accountable or not approve their increase? That should be in your management contract if you're working with a management firm. So, if you don't have an attorney you're already working with, feel free to email me and I'll be happy to look into it for you. But your management contract should be saying what the increases will be. That's generally not something that's in the declaration. Mitch, if mediation reaches an impasse between owner and association, can the association recover legal fees from the owner? Only if you file a lawsuit or you implement the amendment that I mentioned earlier. Otherwise, generally speaking, it's going to depend on your governing documents, but they're probably going to say you only get those fees and costs back if you actually file a lawsuit, unless you work with an attorney like me who is trying to implement some of those changes that we're talking about today. Can responsibilities of a management company versus board be included in bylaws? Yes, but I would just make it simple and say in your bylaws that those operations can all be delegated to the manager instead of trying to be specific as to what tasks you're talking about, and then specify the tasks in the management contract.
Next one's the last one.
Okay. Our definitions for lawn and grass type need for grass versus weeds. If that was never in this, I'm not sure I understand this. Hold on. Let me start over. Our definitions for lawn and grass type need for grass versus weeds. Oh, I think this is, can you define those terms in your architectural criteria, what type of lawn you want to require? The answer is yes, but you won't be able to retroactively say everyone's required to have this type of lawn. And you now that we're making the change, you have to go ahead and change your lawn to St. Augustine sod, even though it was just some plain old grass. So I think that might answer the question, and I apologize. I know there's probably 8 or 9 we didn't get to. Please absolutely feel welcome to email me if I didn't answer your questions today, or if you just want to reach out and see if we might be a good fit to work together, or frankly, if you've got any questions regarding community association law. This education is what we do all the time. It is what our firm has become known really well for, other than doing a damn good job. So, Jeff, I'm going to turn it over to you, but I know usually you'll ask me for some parting words before you finish up. And the bottom line is I just appreciate everyone being on our seminar today. I hope you got a lot out of it. I know that there were a lot of words said, and that's because I wanted to make sure you get the most education you possibly can. But again, feel free to reach out to me, whether it's with questions or if you'd like to potentially work together, or if you'd like to explore working together. My email address, which is the easiest way to reach me, is as@kbrlegal.com. My office is in Orlando, but I have clients in Sarasota, South Florida, up through Tallahassee. So don't think that just because I'm not located in your area, that we don't either have an office in your area or that I'm not willing to travel or meet via Zoom. So again, thank you all for your time today. I hope you got a lot out of it. And Jeff, I'm going to turn it over to you. And my friend, thank you for your help as always.